Hey, it's James, Father's Rights and Resources, how I got custody. I want to talk to you about how I deal with corrupt attorneys, whether it's if I have an attorney who's not doing their job representing me, or a corrupt attorney who's lying in court on the other side. So number one, just about there's some federal rules that are adopted by each state. There's this federal civil rule called Civil Rule 11, and it basically says that anytime anybody signs a document, that means that they're swearing that document, basically they're promising that document was done in good faith, not for any improper purpose, not to harass anybody, that you can just Google Civil Rule 11 and read it for yourself, but Civil Rule 11 also says it's not done for any improper purpose such as harass, burden, delay the other party. And then it says if somebody signs a document in violation of this rule, the court can sanction them upon motion of the party or the court's own motion. So here's the thing with family court. It also says that it's rooted and grounded in law and in fact. So basically, anytime somebody signs a document, Civil Rule 11 guarantees that document is, by signing it, that document is factual, that the law applies, and that it's not done for an improper purpose. Well, you and I both know that attorneys violate that all the time. They have their clients sign documents, or they sign documents lying about you, saying stuff that doesn't even apply to the law, and they want to harass you and burden you. And most of family court is a bunch of lies just to get somebody to wear down and surrender. Every single document in family court almost is in violation of Civil Rule 11. So I asked for Civil Rule 11 sanctions. One time my judge said, oh, Civil Rule 11 sanctions are barely ever granted, and James asks for them all the time. Well, this attorney is lying all the time. This attorney was sanctioned by the court before for falsifying a court order. If he's going to change a judge's written order and then serve it on somebody and make them think they're restrained from their own home when they're not, of course he's willing to lie in his own paperwork, and he's been sued for malpractice. And you say I got a lot of nerve because you don't see people with the audacity to file a Civil Rule 11 motion for sanctions or ask for those sanctions? It's because you're in a corrupt system and you're used to it and you don't like people calling it out. So, in any case, like the mother and her attorney, they'll call me mentally ill Christensen. One document, they said James Christensen, and they put in parentheses MIC for mentally ill Christensen, and they referred to me as MIC about 20 times throughout the document. I asked the judge to sanction them for that, and he wouldn't. So he's basically agreeing that mentally ill Christensen is an appropriate way to address somebody throughout court papers as long as it's the mother's attorney. But, excuse me, the other thing is, attorneys won't ask for Civil Rule 11 sanctions against other attorneys because they both know they're all full of crap. So they're never going to ask for that. That's why it doesn't happen that much. But I asked for it, and I'm also letting the other side know that they're full of crap, and I'm not going to take it, and sometimes the other side will calm down. Sometimes not. So Civil Rule 11 is the number one guardian, as far as in the rules I'm concerned, that I use all the time. And if you read it and you want to apply, I mean, this isn't deep legal mumbo jumbo. Civil Rule 11 says what it says. It says my signature, a person's signature, is a guarantee that this is facts. If they lie in their paperwork, it's not facts. So then it's a violation of Civil Rule 11. So I asked for Civil Rule 11 sanctions. 1 + 1 is 2. Now, attorneys also take, at least in Washington, if you look up, and you can go to, if you want to look up this yourself, don't just believe me, but if you go to Washington courts and click on rules, and then click on civil rules or state rules, and then you find APR, and go to 5, APR 5E or 5D, that's the admission of practice rules, and that's the oath of an attorney. And the oath of an attorney says they will not say anything to disparage or harm or prejudice another party unless it's warranted by the cause. So if they go in there and start talking about you're a cocaine addict and a monster and violent, and you're not, They can't do that. They're violating their oath. And I cite that when I go into court. Also, the rules of professional conduct, you can find those on the court's website. You can just Google them, and a lot of them, the federal rules of professional conduct correspond to a lot of state rules. Like if you go to Federal Rule 2.1, the Federal Rules of Professional Conduct 2.1 in Washington state's local rule or state rules might be the same exact thing. They change a little bit, but they kind of adopt the same thing. In the rules of professional conduct in Washington, there's one called lack of candor, or candor toward the tribunal, which means honesty toward the court. So an attorney is supposed to be honest toward the court. RPC 4.4 says that an attorney won't do anything in bad faith toward the opposing party. So there's these things about honesty and candor toward the court that the attorneys must engage in. Then there's also, in Washington, RPC 3.7 says an attorney cannot be a witness and an attorney at the same time. This is some attorneys do all the time. They'll go in and start talking about the case. Like the mother will say, the father has anger management issues. And then the attorney will say, well, the father has anger issues and we believe he has mental health issues that go with that. Or he's bipolar. The attorney just inserted himself as a witness because he said something that the witness didn't say. Attorneys can't testify under rules of professional conduct. So I asked the court, Your Honor, you need to dismiss this attorney. He just acted like a witness. You can't be a witness and attorney in the same place, so he has to be dismissed as her attorney, or we have to strike that witness testimony. So usually I ask that in paperwork, and family court, as you know, they just go through the motions. They don't pay attention to half the stuff. But I do it to get on the offensive with these attorneys and let them know I'm not letting it slide. And you need to remember and go back and read your ethical stuff. And then I'll file a bar complaint when the case is over against the attorney who does all that stuff and pile it on. Because I'm not letting stuff slip and slide, and I'm not letting them get away with murder like everybody else does. That being said, there's also the evidence rules like ER 602. You can't testify unless you have personal knowledge of something. If an attorney is up there saying, well, the father's home is rat infested and it's dangerous to the child and there's cat poop everywhere and he has a cat, and no witnesses testified to that, then he's testifying again. And even if he was allowed to testify, you can't testify to something you didn't observe with your own eyes. You're a witness. A witness is called a witness because you actually witnessed stuff with your own eyes. So you testify to stuff that you've seen. That's why hearsay is not admissible. You just hear what somebody else said they saw. Oh, this person beat somebody up at Burger King. Well, where were you? I was at McDonald's. Well, you're not a witness. ER 602, you don't have personal knowledge. There's no foundation to your testimony. That's what you see on Law and Order and all those movies. Objection, foundation. They haven't laid the foundation that the person even knows what they're talking about or that they're a witness. And then if an attorney comes in, well, he's got mental health problems. You see attorneys say that all the time. In their own statement or declaration or legal memorandum, and the mother or witness hasn't even testified to that. So how do you know, how are you able to evaluate me with a psychological mental illness? Like they did in that case, in my own case, like I said, they said mentally ill Christensen, just for their own thrills and giggles. How do you know that? You don't, because you haven't sat down and evaluated me, and on top of that, you're not an expert. The Evidence Rule 702 says that you have to be an expert with expert knowledge to present expert testimony. A garbage man can't go to a criminal case and testify and match bullets to a gun. You need a ballistics expert to do that. So the evidence rules prevent somebody from bringing in evidence that's bull crap, that wasn't witnessed, or somebody doesn't have the expert knowledge of, or that's hearsay, basically to make the hearings fair. So when an attorney gets out of line and violates those things, I call them out on paper and I cite those things. And if I have an attorney, they're under the rules of professional conduct, RPC 1.4, or under 1, they're supposed to diligently represent me. They're supposed to communicate with me how to accomplish my goals, not just their goals. Attorneys will say, well, I don't usually do that, or we don't fight like that. No, they're supposed to find out what are your goals and at least talk to you about it. So if they're not doing that, I'm firing them, and I'm saying they're committing malpractice because they're violating that rule too. Or I light a fire under the butt and they do better next time. So that's how I deal with attorneys. That's a short little quick shindig. If you want an appointment or want some one-on-one help and you light a fire under your attorney, feel free to give me a call or contact me.